Who do we have here?
Deshaun Bush.
On the record, in the matter of the people of the state of Michigan versus Deshaun Kelly Bush, file number 21-02197 FY, council appearances.
Thank you. Good morning, Your Honor. Aaron Hopkins on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Bush, who is present and to my right.
Good morning, Mr. Bush. Date that was set for a preliminary examination. How are we proceeding on this?
Your Honor, we will be unconditionally waiving the preliminary examination to bind this over to circuit court to continue negotiations.
Southfield?
Thank you, Your Honor. The people would also unconditionally waive their right to a preliminary examination and ask that the matter be bound over on the complaint as filed.
Is there an offer?
There was not, Your Honor. As Mr. Yang indicates, negotiations will continue at circuit court.
Okay, Mr. Bush, you understand that you have the constitutional right to have a preliminary examination here in the district court? You understand that at the time of your preliminary examination, you have the right to have the prosecution bring sufficient evidence to establish what's called probable cause. So they have to establish probable cause that a crime was committed and probable cause to charge you with that crime. Do you understand that?
Yes, ma'am.
Do you wish to waive that right unconditionally today?
Yes, ma'am.
Okay, so unconditional means you can't come back later and say you would like to have your exam. Once you waive it, it's gone. You understand that?
Yes, ma'am.
Has anybody made any promises to you to get you to waive your right to examination? Anybody threatening you to cause you to want to waive your right to examination? Find your waiver to be made freely and voluntarily. I'll bind this matter over to the circuit court. Your bind over date's going to be November 3rd, 2021. That's not a date that you need to appear at the circuit court, okay? That's just the date they'll get the file from this court. They'll set your next court date, which will be a pre-trial in circuit court. Mr. Yang will be made aware of what that date is. I have a number for you here, 616-377-3612.
You can do 517-749-2059.
Okay. Your address is still the same, so
4126 Baltimore Drive.
correct. Okay. Bond is set at 3,000 PR. That will continue. Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
Nothing for the defense, Your Honor. Thank you.
Well set, sir. Good morning, who's in the jail? Sir, can you hear me? Good morning, who's calling in from the jail? Okay, they may be having a technological issue. We'll put them back. Okay, who do we have here?
Alvin Meredith, Your Honor. 212065.
For the record in the matter of the people of the state of Michigan versus Alvin Meredith, file number is 21-02065 FY. Counsel appearances.
Chris Martin for the people, Your Honor.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Meredith. He is present and to my right.
How are you, Mr. Meredith?
What time is it?
How are you?
Good, you?
I'm good, thank you. Today is the date that was set for a preliminary examination. We were here last week and the parties were still working through discovery. How are we proceeding at this time?
No, that's correct. This matter was set for a preliminary examination today. I've had a few chances to speak with Mr. Yang about the issues that he's encountered with the discovery And I believe that we've resolved those the best we can at this point. At this point, it's the people's understanding that Mr. Meredith intends to unconditionally waive his right to the preliminary exam. The people concur in that waiver, and there is an offer that I've communicated to Mr. Yang that will, that Mr. Meredith can take advantage of at the circuit court level, which is to plead guilty as charged to count 2. And upon successful plea and sentencing, the people will dismiss the balance of the charges in this matter. We anticipate additional negotiations at the circuit court.
Mr. Yang.
Thank you, Your Honor. That's a fair and accurate statement. We will be unconditionally waiving the right to the preliminary examination. As for the discovery issues, they were taken care of in a timely fashion to my satisfaction. I did have an opportunity to speak with Mr. Meredith about the additional discovery I requested. That's how we came up to this conclusion. Therefore, we will be unconditionally waiving.
Thank you. And Mr. Mayor, if you understand that you have a constitutional right to have a preliminary examination here in the district court,
Yes, Your Honor.
you understand that you have the right to have the prosecution establish their burden of probable cause that a crime was committed and probable cause to charge you with that crime.
Sure.
You wish to unconditionally waive that exam today?
Yes, Your Honor.
That means you can't come back later and say you want your exam. When you waive it, it's gone. You understand that?
I understand, Your Honor.
Has there been any promises made to you to get you to want to waive your right?
No, Your Honor.
Somebody threatening you to get you to want to waive your right?
No, Your Honor.
Can't find your waiver to be made freely and voluntarily. This matter will be bound over to the circuit court for a bind over date on November 3rd. You do not need to appear in circuit court on that date. That's the date they'll get the file from this court. Your next court date will be in circuit court. It'll be a pretrial. Mr. Yang will be made aware of that date, okay?
Thank you, Your Honor.
No problem. I have a number here for you, 517-894-1223. Is that accurate?
Correct.
Any additional matters for the record?
Nothing further from the people, Your Honor. Thank you.
Nothing from the defense, Your Honor. Thank you.
You're all set.
Have a good day.
Thank you.
I didn't get it.
Okay, I see Brian Laxton.
Okay, we're back at it, Smith.
Okay, who's in the jail?
Deputy
What's your
Smith.
name?
Montreal Burbridge, ma'am. My apologies.
Okay, Montreal Burbridge.
Yes, ma'am.
Okay, who's representing Mr. Burbridge? Is that you, Mr. Austin? Okay. Who do we have here?
Ontario Roberts.
Okay, Mr. Laxton, this is your client here, Mr. Roberts.
Yes, Your Honor.
Okay. Did you already speak to him privately?
I have not.
Okay, we're on the record in the matter of the people of the state of Michigan versus Ontario Roberts. File number is 21-02404. Counsel appearances.
Chris Martin for the people, Your Honor.
May it please the court, Brian Laxton here on behalf of Mr. Roberts.
Thank you. Today was the date that was set for a preliminary examination. this matter was adjourned back on September 30th because Mr. Laxton had just been appointed as conflict counsel on this matter. I think there was a need for you to get the discovery. Did you get discovery?
I believe I have 99% of the discovery. Mr. Martin and I discussed yesterday one small additional piece of discovery that that he will be sending me, but I'm satisfied I've received about 99%.
That's accurate, Mr. Martin.
Excuse me?
That's accurate.
It is accurate. We've had a number of discussions about the discovery and the nature of the case. And we were prepared to proceed with the preliminary examination today. And as the court may be aware, Mr. Laxton fell ill, and we spoke yesterday, and we determined that it was in the best interest of everybody's health and safety for him to remain on Zoom. But we also know that would require an additional brief adjournment in this matter.
Okay, no, the court was not, or at least I was not made aware that he was ill.
Yes, she got on there and asked me if this was me, and this is not my attorney or anything.
Okay, sir?
Yes,
Mr.
ma'am.
Burbridge? I'm
Yes,
not talking
ma'am.
to you, so I need you to be quiet until I call your name.
I apologize, ma'am.
Thank you. Okay, so Mr. Laxton, you are ill, so that's why you're not able to proceed at this time?
That is correct, Your Honor. I've just some lingering effects of an illness that I thought I had got over, but it came roaring back a little bit yesterday. And Mr. Martin and I discussed that just in the interest of making sure that the court staff and my client were safe, it would be prudent to request a short adjournment in this matter.
Okay. Was there notice sent to my staff that you were sick? Because we wouldn't have had him read it here if
Yes.
we weren't gonna come. Okay.
I'll let Mr. Martin address that, but to my understanding, yes, there was notice.
Okay, thank you.
And if I may, Your Honor, I believe we sent a couple of emails around noon, perhaps, when Mr. Laxton and I conferred.
Okay. It does appear like that staff received that notification. I was not made aware. Mr. Roberts, how are you today?
I'm good.
Okay. I'm assuming you're not good because you were thinking we're going to proceed today. Is that what's going on?
There's a lot of communication between me and Mr. Rice.
Okay. He was recently appointed on there, and I'm not sure if he's trying to make communication with you.
He canceled on me twice. It's my wife he's talking about.
Okay. Okay. Well, it sounds like he's going through some illness right now, and I think that you should attribute him cancellation or canceling on your calls because he's not doing his due diligence. We'll give him an opportunity to address whatever his health concerns are and see if he's able to proceed. If Mr. Laxton's not able to proceed in this matter, then maybe he should withdraw and we can have another attorney.
Your Honor, I am available to proceed. This was a matter of I was fully prepared to move forward. Unfortunately, I have not been able to. I sent Mr. Roberts a very large packet of discovery. It's my understanding that he's received them. I've made attempts to contact him in the MDOC, but given I just have not had that many people at MDOC. So what my understanding was, the person that I needed to contact to do a video conference was not that correct person. And they were able to
contact whoever their litigation coordinator is at that facility.
I understand that at this time. They were willing to offer an unsecured phone line at a particular time, but I didn't think that was appropriate to discuss attorney-client matters over an unsecured phone line.
Okay, I would agree. I think that you're at Bellamy Creek, is that correct?
I'm not Saginaw.
Okay. That may also be the issue. We had you noted on this writ for Bellamy Creek. So you're at Saginaw now?
I got a witness at Bellamy Creek.
Okay,
I'm at Saginaw.
okay. Mr. Laxon, if you don't know who to contact at Saginaw, you can let my staff know and I can get you in contact with somebody.
Thank you, Your Honor. I do know now. I do have that information, and I plan on scheduling something next week for Mr. Roberts and I, because there is that one small piece of outstanding discovery that I want to get to him.
Okay, but you have been appointed on this matter for at least, well, almost a month, so he should have had some communication with you by now.
I just got this 4 days ago, my discovery 4 days ago.
Yeah, sir, I didn't ask. I'll give you an opportunity to address the court. Don't start blurting stuff out in my courtroom, okay? And I recognize you're frustrated, but you're still gonna conduct yourself appropriately, okay?
Yes, ma'am.
Okay, so Mr. Laxton, you're gonna need to make diligent efforts to get in communication with your client, okay?
Absolutely.
Okay, you do have your discovery now, Mr. Roberts?
Yes, ma'am.
Okay, you say you received it 4 days ago?
Yes, ma'am.
Okay, and it sounds like there's still a small portion of it that's still pending. Your attorney is going to make diligent efforts, as he just communicated to the court, to get in contact with you and make sure that there is a meeting with you between now and next week. Because there was a conflict, a need for conflict counsel to be appointed, your 21 days has already been waived. You will have your preliminary examination. We'll just have to reset it at this time due to your attorney's illness. And are you being hold? Are you serving time or are you on a parole hold? You're serving time. And when are you supposed to get out?
2024.
Okay. Okay, how much time are we looking for an adjournment?
Your Honor, we did discuss some dates yesterday and we communicated those dates to your staff. If the court has availability on 11/18, I will be here on other matters that day. And I believe that date is also available to Mr. Laxton.
Yes, we discussed this.
That would also give us time to writ the witnesses, the witness from who's also in the Department of Corrections.
Yes, that's correct. We did discuss this, and that date does work for me.
Okay, we'll reset this matter for November 18th at 8:30.
Your Honor, may I place one other item on the record, just
Yes, please.
in the interest of caution? And I've already spoken to Mr. Laxton about this. We are aware of, obviously the court's aware of the docket congestion and other things that are happening. And just for the purposes of speedy trial, the people will ask that the record reflect that this was an adjournment requested by the defense.
Okay, that's noted. Any additional matters for the record?
Nothing further from the people.
No, Your Honor. Thank you.
Thank you. You're all set for today, Mr. Roberts.
Thank you. Thanks, Mr. Laxton.
Thank you. Talk to you soon. Thank you, Your Honor.
You're welcome.
What time on the 18th?
8:30.
8:30.
On the 18th. Okay, Mr. Burbridge?
Yes, Your Honor.
I'm not here.
On the record, in the matter of the people of the state of Michigan versus Montreal Damo Burbridge, I have file numbers 20-01904, 20-03672, 21-02606, 21-02742 FY. Council appearances.
Thank you, Your Honor. Aaron Housefield, on behalf of the people in the matter of 21-02742 FY.
And Assistant Prosecuting Attorney Adam Pfeiffer for the people in the remaining cases, 20-1904, 20-3672, and 21-2606.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Montreal Burbridge in each of his files. Mr. Burbridge appears to be appearing with us today remotely from the Ingham County Jail.
That is correct. I have a note here that there was a request for an adjournment.
Yes, Your Honor. There's a request for adjournment from the people because of newly discovered evidence, which I can get into and make a brief proffer.
Okay, please do.
Thank you, Your Honor. And if I could approach action documents, I'll help eliminate these.
Yes.
Your copies. These have already been provided to defense counsel in email, as well as, again, this morning to confirm specifically what they were. The first document is a jail call log from Montreal Burbridge to a phone number that is associated with one of the victims, that victim being Miss Jackson. The second document is confirmation in a secure system that the name and address associated with that are those of Miss Jackson. And the third call log, the much heavier one, is from Mr. Burbridge to a number that has been confirmed to be that of the other victim, Minnie James. I will note there are 184 attempted calls to that number. And as I just made defense counsel aware, Mr. Burbridge made 3 more successful calls to that number last night. From my brief review of just some of these calls, as it says on there, there is a cumulative total of just over 7.5 hours in the, I believe it's 18 days that he's been in our jail, to Ms. James. In them, just the brief ones I've heard, he's asked her not to come to court. He's promised to, it sticks by her side when he gets out, he'll give her a baby that she's wanted. And
No.
don't come to court, stay with his mom. His mom will tell her what to do. Yeah, these appear to be very blatant violations of no contact order in his 3 files I'm representing him on. And they appear to provide the foundation not only of forfeiture by wrongdoing for purposes of the examination, but of additional witness interference and bribery. And I frankly need time for detectives to go through these, as I said, over 7.5 hours of calls. I have detectives being assigned to them as we speak, but because of the evidence created by Mr. Burbridge while he's been incarcerated, the people feel that there is an adjournment that's necessary before the preliminary examination.
Thank you. Mr. Austin, you just received a copy, but did you want to respond?
Yes, Your Honor, thank you. I was in receipt of a copy of the call logs that is accurate. What I can say, Your Honor, is that Mr. Burbridge at this point maintains his innocence on that, and we would be requesting, in addition to the preliminary examination, a hearing if it is their desire to proceed with some type of PA 53 violation. As it relates to the preliminary exam, Your Honor, I know Mr. Burbridge is entitled to have that within 21 days that he's been arraigned on the charges in the complaint. What I can tell the court is we would be prepared to proceed today on those original charges in the complaint, and that obviously if there is, the court finds good cause to adjourn the matter, Mr. Burbridge would continue to be housed in Ingham County Jail waiting for his hearing. And so I would ask the court to take that into consideration.
Thank you. I can assure you the court's going to find good cause to adjourn based on this newly presented information. The court's going to also set this matter for PA 53 violations on each file. Mr. Burbridge, you've heard everything that was stated here thus far.
Yes, Your Honor. And with that being
Okay, I
said,
didn't ask, I only asked you one question, so you respond to just my question, okay?
indeed, my apologies. Yes, ma'am.
Okay, so you have the right to have a hearing on the violation or the allegation that you violated the terms of your bond by making contacts to more than one witness or victim in this matter, with the attempt to try to coerce them or convince them not to proceed in this matter. So we will set this matter for a new date.
Your Honor, if I could speak as to the new date.
Oh, well, I'll give you an opportunity in just a moment.
Thank you.
But we'll also be setting it for a hearing on the violation. Your attorney is saying that you maintain your innocence as it relates to the violation of the bond condition. But if you are to be found guilty, you will be found in contempt of the court order, which means you will be facing up to 93 days and/or $7,500 in fines for violating the court's order. Do you understand that?
Yes, Your Honor.
Okay. Did you want to address the new date?
Yes, Your Honor. Frankly, because of the work that's going to be required to listen to these calls, and the extensive number of them, I think at least 2 weeks is going to be necessary. And I would ask that Ms. Housefield's case be adjourned to the same date just for purpose of judicial economy.
Thank you, Your Honor, but I will note that there's no need for a PA 53 in the file that I am representing the people on, but certainly keeping all 4 matters together makes sense.
Have a date for the new exam and then the PA 53, which will be on all of the files except for the one ending in 2742.
November 18th.
November 18th at what time? At 9:30? Time works for both of you.
It does, Your Honor.
Thank you.
Okay. In the meantime, Mr. Burbridge,
Yes, Your Honor.
I don't know if you maybe forgot, there's no contact order that was issued by Judge Ward at the time of your arraignment. It states that you're not to make any communication or contact directly or indirectly with Elarice Jackson. So do you know
Yes.
what directly or indirectly means?
Yes, indeed, I do now.
Okay, so that means you're not allowed to make a phone call. That would be in violation. You can't have anybody else make a phone call. You can't have your mother send a message on your behalf, because that would be indirect. Do you understand that?
Yes, ma'am.
There's absolutely no communication. That goes for Minnie James as well. No communication directly or indirectly. You're not to be within 1,500 feet of wherever they live, work, or go to school. Do you understand that?
Yes, Your Honor.
What you don't want to do is put yourself in a position where you can get your phone privileges taken from you while you're in the custody. You understand that?
Yes, Your Honor.
Do you have any questions about the no contact order?
Yes. It's stating that they said that I have contact with numbers that's supposed to be in my report, and I'm seeing in my report that the numbers what they're probably referring to are 773-949-2099. The 773-688-6038 is my girlfriend, Danielle Smith.
I don't want you to speak about the facts of that at this point, Mr. Burbridge. We can address that at the hearing if need be, but I don't want you speaking about the facts at this point.
Right, because, okay, indeed.
Okay. Do you have any other questions, sir?
No, I will let you guys proceed with what you have going on.
Thank you. So there, your matter's being adjourned until November 18th, is it 18th at 9:30? 18th at 9:30 on each matter. There will be a hearing as well on 3 of the 4 matters on a violation of your bond conditions, okay?
Yes, Your Honor.
Okay. Any additional matters for the record?
All right, nothing for the people on my file.
Nothing for the people on the other files.
Just a couple quick matters, if I may, Your Honor.
You may.
And I'm sure Mr. Pfeiffer will do this, but if I could just get whatever calls that he intends to introduce as evidence at either the preliminary examination or the PA 53 in a timely manner so that I can be able to review them with Mr. Burbridge.
Very well. I'm sure Mr. Pfeiffer will take care of that.
And may I confer with Mr. Pfeiffer briefly before I address the other matters?
You may. All of them except for the one that is Houseville doing. This house is on the weapons one. 2742 is the one that's Houseville. Proceed.
Thank you, Your Honor. And I was just wanting to make sure that we're all on the same page, and this is for my benefit as much as for more it is for the benefit of Mr. Burbridge. But if I could have the people, there has been a global offer extended at this point, and I would like that placed on the record. And if the people intend to alter that plea offer, if these hearings go forward and if some additional charges may or may not be issued, or if there is a violation of the PA 53, how that may impact that.
I would be happy to do that.
Okay.
So I'll very briefly go through it, starting with file 21-2742. 2742 FY. He's currently charged with carrying concealed weapon, as well as firearm possession by a felon and habitual offender second offense notice. At the conclusion of preliminary examination, the people will be seeking to add a count 3 of felony firearm to that matter. And then in file 21-2606, he's charged with unarmed robbery, assault by strangulation, domestic violence third offense, habitual offender second offense. File 20-3672, he's charged unlawful imprisonment, domestic violence third offense, carrying a concealed weapon, firearm possession by a felon, felonious assault, and then 4 counts of felony firearm, as well as habitual offender second. Then in file 20-1904 FY, he is charged assault, strangulation, and DV first. The people will be seeking to modify that to DV third and habitual offender second offense, as he qualifies for both of those. And then, depending on the investigation by the officers, people will be seeking to add additional counts in the 3 files involving a victim of either witness interference or witness bribery. The offer is that in file 21-2742, he would plead to count 1, carrying concealed weapon and habitual offender second offense. No felony firearm would be added, and the count 2 would be dismissed. In file 21-2606, the defendant would plead guilty to counts 2 and 3, habitual offender second offense, and the people would dismiss the top felony, unarmed robbery. In file 20-3672 FY, he would plead guilty to count 2, domestic violence third offense, count 5, felonious assault, and habitual offender second offense. All of the other charges would be dismissed, including unlawful imprisonment, carrying concealed weapon, possession by a felon, and the 4 counts of felony firearm. And then the file 20-1904 FY would be dismissed in the entirety. And as part of a Killebrew agreement that I'd be putting on the record right now, any witness interference or bribery or instigation charges that would stem from the context from the jail, we would not add or seek further prosecution of. That would not include any contacts he makes after such a plea agreement is reached, but all of those made up to that point.
Thank you, Your Honor. That is my understanding of the plea agreement at this point, what I conveyed to Mr. Burbridge. And I appreciate the people putting that on the record and making that clarification, just so we're all on the same page.
I did forget to say this will expire at the commencement of the preliminary examination when those new charges will be added.
Okay, any additional matters, Ms. Austin?
No, Your Honor, thank you.
You're all set for today, Mr. Burbridge.
All right, thank you, Your Honor.
You're welcome. Okay, I see Mr. Toussaint.
Your Honor, do you need me to take those files down?
Yes, he can give those forms to me. Mr. Harris, are you still there?
Yes, Your Honor.
For the record in the matter, the people of the state of Michigan versus Terry Harris have file numbers 21-01977, 21-02590, and 21-01981. Counsel appears.
Thank you, Your Honor. Aaron Housesfield on behalf of the people.
And good morning, Your Honor. May it please this most honorable court, Vincent J. Toussaint. On behalf of Mr. Terry Lee Harris, who appears today by video teleconference, otherwise known as Zoom, he consents to having his hearing heard by same.
Today was the date that was reset for a probable cause conference. How are we proceeding at this time?
Your Honor, at this time, I still have not been provided discovery in this matter. I would like to obtain discovery from Madam Prosecutor. I know that I did just recently file my substitutional counsel to the court. I will need to obtain a copy of the signed substitution by this court, so I can provide either the defender's office, Bingham County, who had previously represented Mr. Harris, or the assistant prosecutor who is handling the order, Ingham County Prosecutor's Office, so that I can know how to proceed in the matter and review all the discovery of Mr. Harris.
Oh. Okay, I see I signed the substitution on the 19th, so that was earlier this week. We'll adjourn this matter to allow you an opportunity to get the complete discovery and review it. And then advise your client as to how you want to proceed at that time. So we'll give you a new preliminary examination date. Where's the it's like earliest? You don't have anything on the fifth? Or the fourth? Is it, you're saying that's busy that day or? Okay, we're not gonna do it on the fourth.
Got a couple of civil trial hearings, so
Just bench trials?
2 bench trials. Yeah.
Okay, this November 5th work?
You indicate November 5th, Your Honor?
Yes.
Yes, that works.
8:30?
8:30 a.m., yes.
Okay, we'll reset this matter for November 5th at 8:30 a.m. The preliminary exam will be held here in person, okay?
That's fine, Your Honor. If I do see whether or not, after I speak with Mr. Harris prior to the November 5th date and we decide to waive the exams, I will contact the court and I'll contact the prosecutor's office to make sure they don't bring witnesses here.
Very good. If he wants to waive, you all can appear via Zoom.
Thank you, Your Honor. And could Your Honor provide me with a signed copy of the substitution of counsel so that I can provide that to the public defender and to the county prosecutor?
Yes, did you want us to email that to you?
Yes, Your Honor. I truly appreciate it.
What's your email?
V as in Vincent, J as in John, my last name, TOUSSAINT at netscape.net.
At what.net?
Netscape, Your Honor.
Netscape.net. Okay, my court officer will send it to you shortly.
Thank you very much. You all have a good weekend and stay safe.
Same to you. You're all set for today, Mr. Harris. Thank you.
You're welcome.
Who is this in the jail? Is this Corey Hale?
Yes, ma'am.
Okay. I've had them put them on for, I think, PCC.
From yesterday? Or,
Yes.
54B.
He didn't show up.
okay, so that is not my case. Just a moment, I can tell the cart. I don't recall who was on that yesterday. It was Adam or Chris.
He doesn't have an attorney, is that the issue on this one? We're gonna mute the court while we find the prosecutor, okay, Mr. Hale?
Okay, thank you.
Okay. Well, on the record in the matter, the people of the state of Michigan versus Corey Hale, file number 21-02740FY. Can I have your appearance, counsel?
Yes, Adam Pfeiffer for the people, Your Honor.
Okay, Mr. Hale, you do not have an attorney. Did you request court-appointed counsel?
Did I?
Yes.
Yes, I did. Yes.
I'm not clear as to why you have not been appointed.
I will say I emailed the public defender's office about Mr. Hale, asking if he had been screened or not, and I did not get a response back. I don't believe he has, though.
Can we see if there's a public defender in the building, please?
I believe Mr. Austin's in the back. Actually, remember yesterday, Mr. Feigelson looked him up and said they didn't even see a case for him in their system.
Okay, so we're gonna get a public defender here. It doesn't sound like you were ever screened, or maybe they don't have that information. Hi, Mr. Austin.
Yes.
Sorry to pull you away. We've been having an issue with people who were arraigned on October 12th, who said they requested court-appointed counsel, but your office does not have any indication that the intake was done. I believe Mr. Hale is one of those individuals. He was supposed to be here yesterday for a probable cause conference. He was in another court as a witness. And so I want to know if an intake can be done today. And then we'll have to address his 21 days because he was supposed to have an exam next week and he doesn't have an attorney yet.
I am here and I can assist in that, Your Honor. I have the spelling of the last name. Is it H-A-L-E?
It's H-A-L-E.
First name?
Corey, C-O-R-Y.
We have one open file. Is this case 21-2740?
That's correct.
I can see if there are any notes that reflect what the status of that may be. It appears that Mr. Pfeiffer contacted our office yesterday regarding this case. It appears that the attorney from our office who did the initial intake forwarded that completed form to the appropriate party in our office. And I'm assuming at this point that is currently being reviewed and or processed.
Okay. Okay, so
But I will make sure to follow up on that today, Your Honor, to see what the status of that is, and we can update the court and Mr. Pfeiffer if there is some type of issue.
Thank you very much. I'll note here that you're gonna call up for us and we'll get a status update one way or the other. So
And yes,
Mr. Hale, I don't know if you can hear that, but it sounds like your application for court-appointed counsel is still pending, okay?
Okay.
Okay, and the public defender's office, I think, is having a little bit of turnover, so they've been a little behind. So once they can get through, or they can process your application, they can determine whether or not you're eligible for court-appointed counsel, and then they can request the discovery, and you'll be contacted one way or the other. The issue that we're going to address today is that you have a constitutional right to have a preliminary examination within 21 days of your arraignment date. You were arraigned on October 12th, and you were scheduled to have a preliminary examination next week, the 28th. However, you don't yet have an attorney, so the likelihood that you'll get an attorney, they'll get discovery, they'll be able to counsel with you, and then be ready to proceed by next week is very low at this point, okay?
I understand.
Okay, so what the court is going to do now is the court's going to find good cause based on the fact that you've not yet been appointed counsel that you requested to adjourn this matter beyond the 21-day time frame. So you're still going to have your right to have your exam. It'll just be a little later than October 28th, okay? Can I have a new date?
What, next week's exam date?
Yeah, we'll treat next week as a PCC.
But don't you have 21 days to have isn't there a 21-day rule though?
Yeah, you have 21 days. That's what I just said. You have 21 days. You have the constitutional right to have your examination in 21 days. You can either waive that right and we can set it for a new date, or the court can find good cause to set it for a later date. You don't have an attorney, so the court is finding good cause.
Okay.
No, so next week you'll come back. We're going to turn your court date for next week into a probable cause conference. And then we're going to set your exam for what date?
September 4th at 9:30.
November 4th at 9:30. Okay, so at this point, those are the dates. Maybe by next week we'll have an attorney here representing you and they'll have discovery. Okay, sir?
Yeah,
Do you have any questions for the court at this time?
no,
Any additional matters for the record?
No, Your Honor. As soon as we get the name of the attorney, I will send discovery and begin negotiations.
Thank you. Thank you, Mr. Austin, for your help.
My
You're all
pleasure,
set.
Your Honor.
You're all set for today, Mr. Hale.